All right, this is very important. This is counsel testifying, okay? And one of the ways that we remove counsel from being able to even do such a thing is Trinzi versus Pagliaro. Although arguments made in, although statements made in arguments in brief are flattering to the court, it is inadmissible before the court, and the court is barred from making a summary judgment based upon hearsay, okay? And the counsel has always got nothing more than hearsay. So Trinzi versus Pagliaro. Statements made in brief and argument, although flattering to the court, are inadmissible for the court to render a summary judgment. Counsel testifying. The worst form of abuse of competence of the competence rule occurs when a lawyer testifies to get facts into evidence instead of asking questions of the witness, who are competent to testify to get the facts into evidence properly. Objection, assume facts not in evidence. Objection, counsel is testifying. Objection, Trinzi versus Pagliaro. Although arguments made in statements and briefs are flattering to the court, they're inadmissible for the court to make a summary judgment based upon hearsay. It happens all the time. You must be on guard for it and prepared to object. When a lawyer begins to state facts outside his own personal knowledge, facts he learned from his clients on third person, facts he lacks competence to testify about in court, object at once. It isn't right. Yet, you'll find this sort of unfair manipulation of facts in nearly every case you come across. Objection, assume facts not in evidence. Objection. The counselor is testifying. Objection. If this guy is a competent witness, I want him removed as counsel, and I want to turn around and subpoena him as a witness so I can cross-examine him and depose him. Objection. All right? Trinzi versus Pagliaro. You know, statements made in arguments and arguments made in statements in brief, although flattering to the court, are inadmissible for this court to render a summary judgment. If a lawyer cannot find tangible items or witnesses to offer as evidence in support of his case, he will frequently attempt to get the evidence in any way by stating facts about which he has no first-hand knowledge. Objection, I want that stricken from the record. Assume facts not in evidence. The counselor is testifying. I want sanctions brought against him for testifying. If he's a witness, then he needs to remove himself as counsel so we can subpoena him as a witness with first-hand knowledge so he can testify to the veracity of the shit that's coming out of his fucking mouth. Detailing the content of documents that aren't available, telling the court what was said by someone who isn't present for cross-examination, or describing a scene or the action and behavior of people he never met. To multiply this unlawful exploitation of due process, most lawyers are adept to using the English language forcefully, illustrating their points with word power most lay person lack. It doesn't matter that they are members of the bar. It doesn't matter that they finished law school, passed the bar, and enjoy a certain degree of prestige, which there's nothing prestigious about their profession, I guarantee it. As they strut about the courtroom in expensive clothing and highly polished shoes that they robbed from their former clients. If they do not have first-hand knowledge of the facts they offer to the court, they lack competence, and a timely objection is essential, okay? Now, when they're testifying, you need to object on the grounds that the counsel is testifying. Now, the judge will say, overruled, he's not testifying. Then I take exception to that as a appealable issue, and I believe that to be a palpable error on your part, Judge, and I want that noted for the record. I object. This guy shouldn't be opening his mouth. He's clearly lying. Well, do you have evidence he's lying? Yeah, he's a fucking lawyer, and his lips are moving, motherfucker. He's lying, all right? Otherwise, if you allow them, they will present damaging evidence in light that dishonesty influences the court against you. Facts about which they have only the knowledge they have learned from others, i.e., no first-hand knowledge of their own. It's all just hearsay. And you will unnecessarily run the risk of losing as a direct result if you don't object and put a stop to it immediately. It is clearly objectionable. You must put a stop to it, or run the risk of allowing the court to consider the lawyer's testimony as admissible evidence. It isn't admissible. No, not by a long shot. The rules forbid it. Lawyers lack competency to testify. And the other thing is, if he's their counsel, he can't testify. If he wants to testify, he has to remove himself from being counsel and come in as a witness with firsthand knowledge, willing to be deposed and take the stand under the pains and penalties of perjury to testify with the firsthand knowledge he may or may not have. So he disqualifies himself from being counsel at that point. It is a corrupt practice. You must stop it before it begins. A particular aspect of the abusive practice needs mentioning to help you control the inevitable. So this might be something that you put in a judicial notice, okay? Trinzi versus Pagliaro. Arguments made in statement or brief, although flattering to the court, are not admissible for the court to render a summary judgment, okay? You can do that on a judicial notice and let them know right out the gate. I know that lying, looting, pandering piece of shit motherfucker is going to try to slick dick Willie me, but I ain't having it today, Judge. And you've been put on judicial notice that if this son of a bitch testifies, I want sanctions brought against his ass. The rules of professional responsibility that govern lawyers, every state has them, limit the ability of a lawyer to be both witness and counsel for his clients. One may serve as a lawyer for a client or a witness for the client, not both. First, if a lawyer insists on offering testimony and the court allows it over your objection, you should move the court for an order finding that the lawyer is a witness for the opposition. Either the lawyer is a lawyer and plays the strictly limited part of a lawyer, or the lawyer is a witness and can no longer play the part of a lawyer. If the court rules that a lawyer is a witness, then move the court to disqualify him to testify pursuant to the state bar rules of professional conduct, which of course you will have already read and be prepared to cite by scripture and verse. Second, if a lawyer insists on offering testimony and the court allows it over your objection and will not disqualify the lawyer, move the court to order the lawyer to take the oath and submit to your cross-examination. Anyone offered as a witness must submit to a cross-examination by the other side. It should be no different if the person testifying is the other side's lawyer. Object. And if the judge overrules your objection or refuses to rule on it, be sure to renew your objection before the court takes any action that would cement the damage. Make sure to take exception to it as an appealable issue. I object on the grounds the lawyer is testifying. And when he overrules you, I take exception to it as an appealable issue. Make your record. Take no prisoners. Otherwise, unwanted evidence will come in without a competent witness, and you will be further injured in your case by inability to cross-examine the lawyer witness. If the judge allows it, object. If the judge will not order the lawyer to submit to cross-examination, object and take exception to it as an appealable issue. And every time the lawyer offers facts as a witness, object. And when appropriate, renew your objection before the court enters any rulings that rely on the incompetent testimony. Remember, your right to rely on the rules was bought with the innocent lives of heroes who died to protect and preserve your ability to require every officer and agent of our government to obey the rules of the law like everyone else. Lawyers and judges are no exception. What's good for the goose is good for the gander. As my granddaddy used to say, he also said, there's more than one way to skin a cat. If you don't get your way in court, prepare for appeal by making timely objections and renewing them at the proper time. When we come back, we'll turn this over into facts not in evidence, or assume facts not in evidence, and we're going to show you how to object to those. Thank you for your time, and we'll see you shortly.